Hello, everyone. My name is Dwayne Kimball, owner and founder of KMD 89, VA Claims Consultant, Leave No Vet Behind, and I am going live with you this evening, and we are going to talk about high-level review, okay? DJ and I, co-worker here, he did a pre-recorded version where he did a presentation. I'm going to share that video with you. It's about 52 minutes long, and he's going to go through explaining the high-level review process, okay? But before we get into that, just as a quick disclaimer, just want everybody to know KMD 89 Consulting is not a law firm. We don't provide legal advice. We don't provide medical advice. We're not doctors, and we're definitely not claims agents. We don't advise the veteran. We only educate veterans on the VA disability compensation claims process so they may be able to maximize their VA compensation benefits, okay? So I'll be looking at some of the comments in the comment section, but I won't answer any questions until after the video, okay? So I think we may be able to get DJ in here in a little bit for the Q&A session at the end. So with see, we got 6 people on board. Okay, so I'm going to go ahead. I'm going to start the video. You can leave some comments, but again, I'm not going to answer any of the questions until towards the end after the video, after this particular presentation. Okay, so let's go ahead and I'll start the presentation.
How you doing? This is DJ and KMD 89 Consulting, Leave No Vet Behind. And tonight, presentation will be on VA higher level review.
Hey, good afternoon, GJ. And my name is Dwayne Kimball, owner and founder of KMD 89 VA Claims Consulting. DJ this afternoon, he'll be doing a video, as he stated, on the VA higher level review. A lot of veterans are still confused about the high level review process. So DJ is going to go through a few slides. So this is pre-recorded, and we're going to share it live in a few days on our YouTube channel. So DJ is going to jump in. He has did some research on the high level review process. He created this presentation. So please pay close attention to it, because it's a lot of information that a lot of veterans do not have. And then they get in the high level review process, and then they run up against a brick wall. So DJ is going to cover a lot of areas as it pertains to the VA high level review. So DJ, go ahead and take it away.
All right. So as Dwayne just stated, a lot of veterans have misconceptions about the review process. And the review process here, we're talking about appeals, and we'll break that down here as we go through the PowerPoint. Starting it off, why is the appeals so important? And as you can see on the slide, on August 23rd, 2017, the president signed the Veterans Appeals Improvement and Modernization Act in 2017. And he said it's one of the most significant statutory changes for veterans in decades. That alone will tell you what we're about to dive into. And we're going to explain the 3 different elements, so it'll have a little bit less confusion for veterans when you get ready to file a claim, a high level claims review, or the other 2 types of reviews. So what we're going to cover is the AMA background and decision notice requirements, explain the high level review process, explain how to use a high level review request, and we'll give a brief example, summarize it, and then return with the FAQs, frequently asked questions. Here are some of the references. That one at the bottom, the hyperlink, benefits.va.gov. Excellent site, covers anything you need to know about the claims process.
Now, hey, DJ, on that previous slide, one thing to note, the difference between the 38 CFR and the M21. In the appeals, they have their own M21 manual reference, opposed to what RBSRs are looking at. And is that the link down below, the VA benefits.gov appeals?
Yes, well, that'll go to everything that covers appeals, and
Okay.
it'll branch out from there. So that's the
Okay.
overarching
Okay.
website.
And I always tell veterans, one thing I like about the M21, don't get it confused. It's not law. It's not regulation. It's not the public law. It's not the 38 CFR. But what I like about the M21 is when you go there, whatever you find as a reference, let's just say, for example, when you go into the M21 for appeals and you're looking up informal conference. Well, when you get there, you see different M21 references. They'll have a 38 CFR associated with it if it refers to that particular condition. So it's just an easy find instead of trying to go through the 38 CFR. I mean, you might be in there a whole hour trying to find something, whereas in the M21, if you find a reference, normally at the bottom, it'll have another M21 reference or a 38 CFR or even a public law with a link that you can click on and it'll take you right to it. So definitely veterans should keep that in mind.
That's correct. And it even cite court cases. And in the court cases for you veterans, it'll give you examples of, well, not examples, but it'll give you the exact court case. So say, for example, you're trying to connect, trying to find a link or a nexus between your PTSD and say your sleep apnea. There's a court case. So when you're searching in there, a lot of great information.
Yeah. And also some M21s will give you examples at the bottom.
That's right.
They will give you examples sometimes with effective dates, say this veteran did this on this date, submitted this, and they'll tell you the actual effective date. So sometimes you will see an example in the M21.
So the purpose, to understand the high level review. Veterans Appeals Improvement and Modernization Act 2017, also called the Appeals Modernization Act, AMA. So you'll hear that referred if you're searching on the VA site, AMA, and that law, August 23rd, 2017. And what it does, it modernizes the current claim and appeals process. Includes 3 review options for disagreement with decisions. Remember at the top of the presentation, I was talking about the 3 ways. Includes 3 review options. Requires improved notification of VA decisions, provides earlier claim resolution, and ensures you receive the earliest effective date possible. So, what is a high-level review? It's a way for the veteran to challenge a decision made, also known as an appeal. It's submitted on a VA Form 20-0996. It's received within 1 year of the date of your last rating. So if you're trying to appeal a decision, it has to be within a year of that decision that you're trying to appeal. You cannot submit additional or new evidence.
And with that, DJ, one thing, I just did a video about some changes that I saw on the 0996. And the 1 year, is that 1 year from the notification letter or the rating decision? Because those, if when you
Notification.
when you receive that rating decision, is that the packet, you have 2 separate documents. You have the notification letter and you have the rating decision. So that 1 year starts from the notification letter, which is normally like a day or 2 after the rating decision. And still veterans are still confused. They'll say, oh, can I submit a lay statement explaining, it's clear on that 0996. They're only going to review the evidence that was of record when they did that rating decision. That's it. Right. There's no, let me send a x-ray or a lay evidence from my wife, my sister, my dog, none of that stuff. No additional evidence. Yeah.
That's right. And a simplified way to explain that I was explaining to a colleague a while back is similar to a test. Say you're in school, you're in college, or even high school. You fail a test, or you get an F on the test, and you're trying to challenge that grade. Now, you're not going to go to the teacher and submit new information regarding to the test. No, they want to know everything
Right.
that's regarding that test, not anything new in addition. So same thing with a rating. They made the rating based on all the evidence of record. And when you say that they made a mistake, now it's you have the burden of proof to find the mistake and present it to them.
And even on that 0996, I talked about in that video that I uploaded earlier this week, it states you and or your representative to point out errors.
Right.
And one point that I made, how can you do a high level review to point out errors if you don't have a copy of your claims file? With the CMP exam, if you had one, and or the rating decision. So, I always tell people, how can you do, you can submit a high level review, but how can you win
Right.
if you cannot point out the error? And people say, oh, well, they didn't take this into consideration. Is it in the evidence section? Yes, they took it into consideration. They reviewed it, So that's one thing that, I pointed out on the 0996, and it's something that they rephrased, and a lot of people don't read that instruction. I think it's at the first couple of pages of the 0996. They don't read it because it's there as well, no new evidence. And it talks about the point out errors, just like you said.
So this is what the VA wants you to know. And you can find this on that link that I provided. And it's going to speak to the 3 different ways.
VA is cutting down on the traffic and wait times in the decision review process. Have you heard? Thanks to the Veterans Appeals Improvement and Modernization Act of 2017, veterans like you now have a choice on how the review of your decision is processed, so you can get the fastest decision possible. The new and faster Appeals Modernization Review process goes into effect February 19th, 2019 for any eligible VA decision disagreements and offers more choices in how decision disagreements are processed. Veterans who receive initial claim decisions after February 2019 who disagree with that decision fall under the new process and have multiple review options or lanes. With Appeals Modernization, you get to choose between 3 new lanes to have your decision disagreement reviewed. You can choose from the higher level review, the supplemental claim, or the appeal to the Board of Veterans Appeals. A higher level review means that your disagreement is reviewed by a more experienced claims adjudicator. In this lane, you can't submit any additional evidence for your claim. It's reviewed with only the information considered in the previous decision. You and or your representative can also request to have an informal telephone conference with a higher level reviewer about your disagreement. The supplemental claim lane gives you the choice to submit new and relevant evidence to support your claim before it's reviewed again. VA will even assist you in gathering evidence. This lane is helpful if you know there is missing information from your original claim or you have new and relevant evidence to submit. Then, a claims adjudicator will review your claim along with your new and relevant evidence. The appeal lane allows you to appeal directly to the Board of Veterans Appeals with a Notice of Disagreement, NOD, and choose one of 3 options. You can choose a direct review if you do not want to submit new evidence and do not want a hearing. You can choose evidence submission to submit new evidence without a hearing. Or you can choose a hearing to submit new evidence and have a hearing with a veterans law judge. All of the lanes provide veterans with faster resolution of their disagreements. VA is working to decide higher level reviews and supplemental claims within an average of 125 days, and decisions from the board in the direct review docket are given within an average of 365 days. All of these options are significantly better compared to the 3 to 7 year long wait under the old process. Appeals Modernization puts you back in the driver's seat of your disagreement and gets you the faster decision you've been waiting for. Want to learn how you can get your decision faster? Go to benefits.va.gov/benefits/appeals.asp.
All right. As we have just seen, there were 3 options presented: the higher level review, the supplemental claim lane, and the appeals lane for the appeals to the board. Now we're just discussing higher level review here. This is the focus. So that AMA that they were talking about, the AMA improved decision notice requirements. AMA requires the following 8 elements in all decisions issued. So the first, identification of the issues adjudicated. So when you get that decision, you're going to have number 1 through 8. A summary of the evidence considered. You're going to see they're going to have evidence, and then underneath evidence is going to be all the evidence that was reviewed and considered. For example, service treatment records, private treatment records, medical opinions, lay statements, so on and so forth. Number 3, an explanation of the laws and regulations applicable to the claim. So if they denied it, they're going to give you the reference, 38 CFR reference. Summary of any findings made by the adjudicator that are favorable to the veteran. Favorable, those are favorable findings, and they'll be marked as such. So you'll see a denial on your rating. You'll see the summary of the evidence. You'll see the laws, and then you'll see the favorable findings. And I'll explain that a little bit later. Number 5, for denied claims, the identification of the elements required to grant the claim that were not met. 6, if applicable, identification of the criteria required to grant the next higher level of compensation. So if you're at 10% and the next higher level is 30%, they're going to identify what the next level of what do you need for the symptoms for that 30%. So if you need 30%, you'll see right there in front of you what's required. So you don't even have to guess. If your symptoms have worsened and you meet that criteria, then you can reach out for an increase. Number 7, an explanation of how to obtain or access evidence used in making the decision. Number 8, a summary of the applicable review options available for the veteran to seek review of the decision.
DJ, go back to that previous slide, if you will.
Yes.
I want to touch on 6 and 7. If applicable, identification of the criteria required to grant the next higher level compensation. A lot of veterans miss this. In every rating decision that you receive, they have to tell you, if they grant service connection for 10%, what is the next higher? And you can also obtain a disability summary breakdown letter, which will have all the conditions you're service connected for, the percentage, and the diagnostic code. I can't tell you how many veterans say, oh, I'm getting shots in my knees. I'm, on this medication, that medication. The first question I ask them, is that in the requirement for the next higher evaluation? They say, where can I go find it? You can find it obviously in the 38 CFR in the rating schedule, or you can find it in your rating decision for that particular condition. But you got to have a copy of your claims file to get that. And then number 7, an explanation of how to obtain or access evidence used in making the decision. In all of YouTube videos, in the description section, click that little show more button right down there at the bottom in the lower left-hand column is grayed out, show more. You click on that, and I show example, I provide the blueprint word for word, the link to the form I use and the verbiage, the fax number, and the mailing address of where I submitted my Privacy Act request to get a copy of my claims file. That's what they're talking about in the 6 and 7, and that's what a lot of veterans miss.
Yeah. So on there, you saw, let's see, which one was that? Number 4, right here. Summary of any findings made by the adjudicator that are favorable to the veteran. So a veteran might say, well, I was denied, but they say that they saw an instance in service where, let's say, for example, you claim a left knee injury. Well, they say that they have proof that I had an incident where I reported left knee pain. So they would cite that in this rating, and it'll be under favorable finding. And as such, any finding favorable to the claimant made by either adjudicator or the Board of Veterans Appeals is binding on all subsequent VA and board adjudicators. So Once they list that favorable finding on your rating decision, and then it'll be a denial, then they'll have to list a favorable finding. That is just them listing evidence that if they were to grant, it will be used to grant.
So
And-
what you're saying is, even though I have the incident in service, I get a C&P exam, the doctor gives a negative opinion, and even if the rater puts favorable findings in the rating, then me as a veteran, well, they put favorable findings, so I should have been service connected just because they put favorable findings in there, correct?
That's what some people think, but it's not correct. So for example, in this instance, I'm the vet. I'm claiming left knee injury. In service, they show that I went to the doctor. I claimed left knee pain. Well, I was seeing for left knee pain. They issued some Motrin, 800 milligrams Motrin for 3 days. Then it resolved. Now, 10 years later, I'm out of the service. I want to claim left knee injury. Well, that one time doesn't not necessarily mean you currently have a left knee injury today, 10 years later, and that instance in service caused it. So there's a lot, I wouldn't say a lot, but there's more evidence that would need to link your current condition and what happened in service. So that is where some veterans go wrong. They think just because there was a one-time occurrence, if you have an injury now, 10 years later, they should be an ongoing picture of your symptoms continuing since service. And if not, they want to know why. And I mean, but sometimes it is not necessarily the year after. Sometimes these things build up and we have busy lives and some things take precedence. So there's ways that you can go about acquiring that evidence.
And even in the last video, when you talked about favorable findings, a lot of veterans miss if they get a C&P exam. They'll say, well, they said favorable findings. I'm like, well, do you have a copy of the C&P exam? Because more than likely, if you had a C&P exam, the doctor provided a negative medical opinion. And the rater had to deny the claim. And I can remember my first claim, I didn't file it for, I think it was both knees, let's say in the right ankle and tinnitus that I got service connected for. So for 12 years, I didn't submit any evidence, but they had the incident in service. And I stated that, hey, please concede me being competent to provide my current symptoms and request a C&P exam. So as you stated in that previous live video that we did about favorable findings, you have to be able to reasonably articulate your symptomology when you get to that C&P exam. You just can't be talking about, this, that, and other. You got to get, down and to the point and be able to explain your symptomology, and
That's right.
Some examiners are a little bit harder on veterans than others, but to come back and they deny it, you had that treatment in service, like you said, left knee, and you get a C&P exam, then it's the doctor saying no. And you're not going to know what the doctor put in that exam unless what? You have a copy of that class.
That's right.
Yeah.
That's right. Yeah. And see, and that again works to your benefit. You see, he was already explaining to you that you need copies of your medical record. So if I'm going to claim that someone made a mistake on issuing me compensation or granting it and not having the actual document that states what error was made, puts me behind a power curve. Now I'm trying to play catch up. So, and that goes to that number 2 right here. Favorable findings relate to a material element that will be required to grant the benefit sought. So in this case, in favorable findings, you'll see veteran reported to urgent care for left knee pain, and that was it. So that'd be an example.
Right. Or, especially I've seen where I called an exam insufficient, one of mine, because the examiner failed to ask certain questions, and then the rating specialist did not go back and ask for clarification. they just went ahead and denied the claim. And that's how I found that error. But I had a copy of that CMP exam. And I was like, hey, wait a minute. This shouldn't have been granted. This should have been sent back as an addendum to the CMP office. And the examiner, the rater should have asked the examiner X, Y, and Z. So when you get to that high level review, guess what? That's the error that you're pointing out.
That's right.
So that decision review officer will be like, oh, you know what? You're right. Let's go out for that addendum, and then it's up to the examiner to look at it and say, oh yeah, I made a mistake. Yes, this should have been granted, especially if they say, oh, well, I don't see, and I've seen this happen where examiners give a negative opinion and they say, well, the veteran has a current diagnosis, but I don't see any treatment in service. Now, you can say you were treated, but it's not what you say, is what you can prove. So if you have a copy of your claim, VA claims file, and you have a copy of your service treatment records, when you get to the high level review, you can say, oh, wait a minute. The examiner said that they didn't see any treatment in my records. I see I was treated multiple times.
That's right.
The rating specialist should have went back out and said, hey, wait a minute. You missed it because the veteran was treated on this day, this day, this date. Please review the treatment on those particular dates and provide an updated medical opinion and rationale. Rater should have caught that. But if you don't have a copy of your claims folder, how can you prove that error? You know what I mean? You can't say, well, they didn't take this into consideration, because if it's in the evidence section, you don't have a leg to stand on it when you say they didn't take it into consideration, because they're telling you everything in the evidence section they review.
Right. Now you got to remember, all this that we're talking about is basically law, because once a favorable finding is entered, that's law. It can't be removed. So if they say that you were denied left knee on your rating, then 2 years from now, you're coming back, you want to reopen that, and they say, well, you never had any incident in service. Well, on this previous rating, you showed that in service, I reported for left knee pain. So that's law. And so that's one of the things that Dwayne is talking about.
How do you use that to your advantage? You know what I mean? Especially
right.
if you get denied, you got to turn around and be able to use it to your advantage. I always say you got to be able to speak that VA language. You got to be able to recognize it and then be able to speak it and use it to your advantage if you can.
Right. And you guys watching these YouTube videos that we're making them for you. We're not making them for us. We already know that. It's for you. We're giving you the information so you can make smarter decisions and proceed wisely for your own benefit.
Don't be frustrated. Get educated.
Right. So as you see here on this slide, again, it's covering those three different ways: higher level review, supplemental claim, Board of Veterans Appeals. And on this one, higher level review. So here's an example of how to utilize a higher level review. Wayne so eloquently went over an example before. Now this is another one. So let's say, for example, you got your rating decision and it shows the following. You were denied for tinnitus in 2017 in January. So your service records don't show an injury or auditory decline in service except one complaint of ringing in ears. Your subsequent medical records are silent for any complaints and no current evidence of a disability. So this is all on that rating decision that you received. So you get the rating, you watched some of our videos, you did the research. Now you figured you were a jet engine mechanic. So that was a favorable finding. Why jet engine mechanic? Because that's on the noise abatement, right? That's high probability of noise exposure. So now you're putting that evidence together for your case.
That acoustic trauma. Being exposed to, the acoustic trauma, yep.
Right. And number two, you stated on your disability application that you had ringing in the ears since service. Now, you as the veteran, you're competent enough to let someone know that you have ringing in your ears just by stating that. I have ringing in my ears. You don't need a medical professional to present that for you. So this was something that you identified on your application. Number three, you submitted a positive medical opinion that was not considered as evidence. And how do you know? because you had a copy of that document that Wayne was telling you. Get a copy of it. So you have a copy of it. You went back through, you did your research. You're like, wait, I did submit a medical opinion and it says I have a diagnosis of tinnitus. So now you're putting that evidence together. Number 4, you submitted your claim on August 19, 2016. Why I say that? Because you watched the videos, you were educated, you know that that's a presumptive condition. You submitted that within that 1 year of exiting the service. So when you present all 4 of these steps, you are successfully overturning that decision, because these are strong facts that work in your favor for a grant, a service connection for tinnitus.
And you said one thing, DJ, that I want to point out. When you said you worded it that way on your claim. You know, one thing that in one of our trainings on how to be successful in the VA claims process, we have a topic where we talk about how we were successful in wording our VA claim. You know, so something like a jet mechanic may read, I am claiming tinnitus, ringing in the ears. I was exposed to acoustic trauma as a jet engine mechanic, in parentheses, please see my DD-214 for confirmation. And then, you know, please schedule me for a CMP exam to obtain a medical opinion and rationale. Just something like that. You know, if you just say I'm claiming tinnitus, you know, that's still not bad, but you want to give them the what, when, why, and how. You're claiming it on a direct basis. You're letting them know, hey, I was exposed to acoustic trauma due to my MOS, which can be confirmed by reviewing my DD-214, and you're asking for a CMP exam to obtain a medical opinion and rationale. So when you get to that exam, like you said before, DJ, you gotta be able to reasonably articulate your symptomology. You know, so you got to talk about, you know, if you're on the flight line or flight deck, if you're in the Navy, you know, how you exposed, were you wearing earplugs, when did the ringing start, is it constant, things of that nature.
Right. And by you doing that research and being smart, because you watched our videos, so that once you put that verbiage in there on your application, I have ringing in the ears, or, you know, on your 4138, you're self-diagnosing. That's telling them right now, currently, I have an issue. And that's what it is.
Yeah, like you said, you're competent as a vet and not a medical professional to provide those symptoms. You're competent enough to do that. And that's in the M21 as well.
Right. And you know, that's on particular instance, especially like shoulder pain and, you know, simple things, not like mental condition or diabetes and things like that. So you did the research, you found the evidence that they missed, because you have the current rating decision that denied you. You have all your documents that they were speaking about in the evidence. You notice they missed one important thing. That was the link. That was the positive medical opinion. Not only that, you submitted it within a year. That was presumptive. You identified that you were exposed to high levels of acoustic trauma by your MOS or your AFSC if you're Air Force. And then you stated that you have a current issue, your current disability via your application.
Now, did the VA update the 38 CFR 3.309 subpart A, the 1 year presumptive? Did they add the tinnitus to that 1 year presumptive? I have to double check that. Yeah.
Let me pause.
Yeah, we could look at it later.
Okay.
But you know, one thing, I don't remember if they did, but when I went through training, actually, I wrote it in my rating schedule that they did add it. But also with tinnitus, keep in mind, if the M21 states, if you were diagnosed with tinnitus in service, no matter how long you've been out of service, they do not need you do not need a medical opinion. You just need a current diagnosis of tinnitus. And that's I know that's in the M21, and I don't know if that particular M21 has a 38 CFR attached to it. But I did a YouTube video. So if you go back and look through, if you go to my YouTube, go to a YouTube channel, you can see a video that I did. I think it was last year where I talked about tinnitus, and I give that M21. I showed that M21 reference. I can't remember if I put it in the description section, but I did do it. Show it in a slide. So just keep in mind, if you were treated and diagnosed with tinnitus in service, if you've been out 10 years, and let's just say the doctor gives you a current diagnosis of tinnitus and a negative opinion, and the rater denies it, then that's an error. And the reason why I remember that so much, DJ, is because that's the first error that I ever received. A veteran was actually, I think he complained about tinnitus in service. Exam was requested. The doctor gave a current diagnosis of tinnitus, but provided a negative opinion, and I denied it. And man, that hit me with that error so quick, and that was the first error that I received as a rating decision. And going forward after that, I always would make sure I would try and take the extra time to dig into the M21 and making sure that everything was done correct.
You brought up a good point about the presumptive other organic diseases of the nervous system. So
yeah, peripheral neuropathy falls under that. Yeah,
right. So I'm gonna need to correct this slide.
Yeah. But that's fine. We could we could share that in the description section.
Okay.
As well. Others video.
Okay.
Yeah. So we can go ahead if you want. Yeah, there we go.
Okay, the new VA goals. So with higher level reviews, the new goals are to decide your review within 125 days of submission. And for the Board of Veterans Appeals, that's 365 days. So remember, those was three ways. There was a high level review, and where you don't submit any new evidence, supplemental claims where you can submit new evidence, and then the highest, which is the Board of Veterans Appeals. The old process took 3 to 7 years. So from 125 days, years. You can see the big benefit. So there's a lot of complaints. You hear a lot of people complaining, but keep in mind the VA is working with a lot of individuals, and they're doing a great job. And especially with rules like this, cutting stuff down 125 days as opposed to years.
Yeah, and I remember when it was 3 to 7 years, and vets complain now about 125 days. Think about like in 09, 2010, 2011, you talk about 3 to 7 years before anybody ever looked at your claim. And one of my videos, I explained how I cut that time down to 10 months. And back then they didn't have that informal conference. And I asked for informal conference. When I asked for that informal conference, they had to do that rating decision within 7 days. I had, back then you could submit new evidence. Now you can't. And I had that informal conference, and I submitted new evidence, and about 10 months. It took about 10 months. And I was dragging my feet of, at least 60 days of that. But yeah, the VA, this is an area that I think that veterans don't recognize, where the VA has done a lot for veterans by, they cutting that down more than 75%, the time. You're talking about 125 days, and then the Board of Veterans Appeals, you can get in front of a judge in a year.
Yeah, and that's just within the last 3 years.
Right. So think about
3 years.
Right. So think about going to BVA, waiting 3 to 7 years, 7 years just to get in front of a judge. And then that judge turn around and do a remand. And I remember remand having one of the smallest teams,
right?
Specialists. Exactly. So now you're talking about another 2 or 3 years, So for them to go from 7 years to 125 days, man, they put up, VA's done I think a tremendous job in cutting down those wait times.
So a summary of what we covered today. The Veterans Appeals Improvement and Modernization Act of 2017. Again, the goal was to reduce the process, right? So you can see they reduced it from 3 to 7 years down to 125 days. Now we're talking about high level review. And higher level review is a way for the veteran to challenge a decision made. So if you were denied, you look at your rating decision, it gives you the actual regulation. So you look the regulation up, you match that with your favorable findings, and then you see what the evidence was that they reviewed for your claim, because they have to cite that, as you know. The higher level review is submitted on a 20-0996 within a year of the last rating notification. Also, you cannot submit any new evidence or additional evidence. So everything is based on items of record. So if you're disputing a rating decision that an error was made, then the only way to review that is review all the evidence that was considered at that time. And if there was evidence of record that wasn't considered, you can cite that, because that was of record at the time of the rating decision. Here's a couple of frequently asked questions. Now, this is directly from the VA website, not from us, directly from the VA website. What was the average wait time in the old appeal process? So higher level review is an appeal. On average, veterans waited 3 years for resolution. Board of Veterans Appeal cases waited an average of 7 years. How does appeals reform relate to modernization? Again, AMA, modernization. The goal of modernization is to simplify. So they wanted to simplify the process. They give you a dedicated form. That's the 20-0996. You complete that. Then your time in queue, 125 days.
And just to recap on that, DJ, I think the VA has simplified that process, because before it was definitely confusing. But I see how it could be confusing now to veterans, because they didn't go, or maybe some vets did, but most vets hadn't went through that old process. But at the end of the day, when they say you got to point out errors on that 0996, it says you got to point out errors. You got to be educated on how to do that, to point those errors out. You know, I don't know how long those phone calls are for those informal conferences. I talked to a couple of veterans and they say, oh, we was on the phone 30 minutes. What are you discussing in that 30 minutes? You can't say, oh, just let me tell you my story. You don't have time for that. You got to say, in this rating decision, I should have been service connected because my doctor did a DBQ and the nexus statement, but you have to be educated on, is that DBQ, the nexus statement, actionable and sufficient for rating purposes? If it is, then you can say, oh, I should have been granted, even though your doctor said a negative opinion, because my doctor looked at the same information. So at a minimum, I should have been granted based on reasonable doubt. Reasonable doubt should always go in favor of the veteran. But if you don't have all that information, you can't reasonably articulate that in that informal conference. You know, so a lot of people say, oh, I just got a nexus statement. Well, if you're claiming on a direct basis or secondary, you need a DBQ. You just can't check that box on the 526CZ and say, oh, I got a nexus statement and expect to get service connection. The DBQ is going to show the diagnosis and the current residuals, you know. Right. So a lot of veterans, you know, they miss that. And then they say, oh, I'm going to do a high level review. And then when they say, oh, they denied me on the high level review. Well, why did they do that? Why did they do that? Oh, they didn't take into consideration my DBQ. It's in the evidence section. They did, you know, but you couldn't explain reasonable doubt when you went to that informal conference, and or your nexus statement was insufficient.
Right. And a lot of veterans, what they don't know is when you request a hearing, you're going to be doing most of the talking. You or your representative, not the rater, because they already have the decision. You are trying to influence them that what you're saying is correct, that an error was made. So you're going to be doing the talking. You're going to have to show cite what reference you researched to prove that it was wrong, what evidence was of record at the time to prove that the decision was wrong, and basically articulate that. So you're going to be doing most of the talking, so it behooves you to get all your ducks in a row. And you can do that by especially looking at this slide. If you go to that video, it tells you the 3 lanes that you need to follow and the requirements for those lanes. So you pick whichever lane that suits your case the best, get all that information together, and then pursue it, because there's a particular form for each lane. You got to cite the evidence for each lane. You have to cite the error for each lane. So it doesn't change. You see the theme here. You got to articulate your case regardless of however you present it. If you're saying somebody made a mistake, then you have to prove they made the mistake.
Exactly. It's not what you say, is what you can prove.
That's right. So the last one, what is the plan to address pending legacy appeals? So for all those people that had appeals pending before this new change in 2017, the VA cites this, and this is a quote: "We are committed to addressing the inventory of legacy appeals. We met with stakeholders and partners to determine the best options. Then we identified 2 opt-in options for legacy appeals. These options are included in the AMA, that's the Appeals Modernization Act. We will continue to examine other opportunities for veterans with pending appeals." So you have to remember, some veterans are not versed in the appeals process. You just went through a small piece of it right now, a small piece of it, highlighting higher level review. So imagine a person that's thinking that they're right and the VA is wrong, not knowing this process. They submit an appeal, the appeal is pending, they wait 2-3 years, they address it. Now they addressed it at the lower level. They submitting for a higher level review or a board of appeals, and they're still doing the same thing. They're making the same mistakes. So those are some of the things that are clogging up the system too. Multiple appeals that are not properly prepared. So you're going to have that in the system. So in summary, we covered the AMA background and decision notice requirements. We explained the higher level review, examples of how to use the higher level review request, summarized it, and covered some frequently asked questions. So this is a big step. Social media 2021, you have access to information. These YouTube videos, CAMD89 is producing, are top notch. And if there are any errors, you guys see anything, have any questions, make sure you put them in the comments, because no one is ever 100% correct. That's to include the veteran, to include the VA, period. So what we're trying to do is bring the veteran top-notch service, excellent information, and we want to do it so that you guys have access to it 24 hours. This is a video. If you're on graveyard shift and you know that you want to submit a claim for yourself and you don't have the information, or you're confused about something, go to kmd89.com and you're going to find those YouTube videos. Go to the YouTube channel and you can work on your claim. There's no excuse for you not being able to present yourself properly, because you have the information in front of you.
Exactly. And also, I just like to add, this is a service that we provide as well. We do we do a claim audit. I've looked at information for veterans back, 10, 15, 20 years to see, was there an error made? So we'll review it. We'll complete a report on our findings, and we'll go over those findings with you, so you understand, why the VA said no, why the VA granted this particular effective date, why the VA granted a particular percentage. Now, without the CMP exam, we can, only assume, because the CMP exam, that DBQ is going to show the current residuals as it pertains to the diagnostic code criteria for different percentages. But that's one of the things that we do is claim audit review. We have that listed on our website, and also our educational classes on our website. How to be successful on the VA disability compensation claims process. What information goes into a nexus statement? How to read a DBQ. We have live Q&A sessions every Friday at 1 p.m. Eastern. And also we do private Q&As, and those that be set up because DJ's doing those. So, you know, they have to coordinate the time between the vet and DJ. And that's not a how-to session, but for you as the veteran to ask questions, maybe as to how a particular VA claim, a VA reference or a 38 CFR may impact, you know, what you're doing with your particular claim. So it's about being educated. Okay. That way, like DJ said, you get in front of a decision review officer on appeals, you got to be able to explain yourself. And it's about being, and you can't do that, one, if you don't have a copy of your claims folder, and two, if you're not educated. Because then you got to be able to point out those errors. And they state that, you know, more than once on that 0996. And a lot of people like the 526CZ, the 0995, and the 0996, there's several pages before you actually get to that claim form detailing information. I went over the supplemental claim and I showed I took some screenshots of those pages, as you know, and I was talking about the difference between a FDC claim and a supplemental claim, and they break it down for you. But people still think, oh, just because I selected FDC, that's automatic. That doesn't mean that's automatic. That just means you have no other evidence to submit. That's it. That's it. Doesn't mean just because you were treated service and you got a nexus statement, it doesn't mean that. So I just wanted to point that out.
Right. So if you see on these on the screen, that's the contact information. So if you want to reach out to KMD89, that's the contact information there. KMD89.com, 855-SOLDIER or 765-3137. And we provide a lot of services for veterans along the lines of educating. Once you're educated, you can do everything yourself. Not just once, multiple times. You know, being a veteran, you're in the business of potential harm, not just to other people, but particularly to yourself. You're training, you're carrying loads on your back, you're getting in and out of vehicles, high-powered vehicles, high-powered aircraft. I mean, you're exposed to acoustic trauma, burn pits, a plethora of things. So one thing can trickle, and we've seen this with Agent Orange. So a lot of people have been talking. The word on the street is, you know, later on down the line, there's going to be some things coming out about Afghanistan, Iraq, and things of that nature. So if you have all your ducks in a row, you have your treatment records, you stay on top of it. Once you're educated on that claims process, you can file for something later if something comes up. You're educated on it. You'll be able to make smarter decisions.
Right. So DJ, I'd just like to say thank you for putting this PowerPoint presentation together. And this is the recorded version. So we're going to go ahead and stop the video. We're going to take some questions, a couple of questions from the comment section. So DJ, I definitely appreciate you putting together this presentation and presenting and giving a better understanding of the high-level review claims process and that whole AMA background.
My pleasure. My pleasure.
Okay. All right. So let's just go ahead. We're going to wrap up. You got something else, DJ?
No, go ahead.
Okay. We'll go ahead and we'll stop the recording, and then we'll go ahead and get to the Q&A session and take some questions from the comment section. All right. Thank you. So hello, everyone. Back with you here. I'd like to just say thank you to DJ for putting together that powerful presentation as it pertains to the high-level review process. And like I stated earlier before this video, we wanted to wait till after the presentation to get into a little Q&A. So see, we have about 45 people in the live stream tonight, and I'm just going to pop up the questions. But before I take the first question, just wanted to ask DJ, is there anything that you wanted to add to that awesome presentation that you put together?
Hello to everyone. Yes, I do. In there, you had mentioned something about them updating the 38 CFR, and we're trying to. I was trying to find it, but the CFR hasn't been updated, but the manual, the M21 has, and in the manual, I can put it in the chat, but the manual confirms that sensorial, hearing loss, and tinnitus are considered organic diseases of the nervous system and are subject to presumptive service connection under 38 CFR 3.309A. So we weren't in error. We just wanted to put the correct reference in there. I mean, because if you looked at our reference, it'll say 38 CFR 3.309A, like I just stated, but that CFR hasn't been updated. What the government did, well, the VA did, they updated it in the M21. That's a manual reference.
Yeah. I wonder why they did that. They didn't, I would think that, the M21 is not law and the 38 CFR is, and why they didn't just, put it in the 38 CFR as well. But
Oh yeah, they update them on, I forgot the increments. I think it was 2 to 3 year increment.
Yeah. Okay.
For that update.
So, all right, let's get into the first question here. I'm gonna pop it up on the screen. Take a look at it. Demetrius, is there a time frame for response to motion to advance in BVA evidence appeal? I'm not really understanding that question.
Are you saying you trying to expedite the BVA appeal? I'm trying to figure that one out as well.
Yeah. Maybe he's saying, is there a time frame after you receive the denial of the actual appeal from the DRO or the SSOC, that denial? Is there a time frame that you have to submit to BVA? I don't know if that's the actual question or not, but
well, if it is on the decision letter, it'll state the requirements for an appeal. It'll give you all that. They'll even provide you with the form to submit an appeal with that decision. So if that is the question, check out your letter. It'll have the reason they denied it. Also, it'll have, if you disagree with this decision, then it'll explain what your options are.
Okay.
Hope that answers your question.
Yeah. So let's move on. Got Melvin Smith. Hello, DK. Keep up the great work, bro. Not a problem. It's our mission and our passion to educate vets. So definitely appreciate the feedback on that. We don't have as many questions in here. Here we go. Here's one. Dwayne, it just went from 30 to 100% PNT with the SMCK. Your videos definitely helped me out a lot. Wow. So, hey, congratulations, Preston.
Congrats.
Yeah, good job. Good job. Glad that you found the videos very educational and informative as well. Here we go. Eddie says, a high-level review requested another CMP exam. I pointed out to look at my separation exam. It showed I checked knee pain during the separation exam. Does the separation exam count as medical evidence? Yes, it's part of your service treatment records. So, yeah, it counts as evidence as to why they requested another CMP exam. Who knows? That only individual that requested it would know the answer to that question. Now, if for some reason, you have another hearing or something like that, or you call the 800 number and you ask them to look at the last 25, do they still call them 2507 requests, DJ, the medical requests when they request the CMP exam?
I believe so, yes.
Yeah, so if you call the 800 number and ask them, and the VSR may not do this because I've had other veterans call in and ask that, question can you look on the 2507 request and see what exams were requested? And that VSR at the call center said, I don't know what a 2507 request is. And the reason why I'm laughing, if anybody at the VA should know that, especially not anybody, but VSRs and RVSRs, droves, they should know that, because at one point in your career, you've requested an exam. I requested hundreds of them before. And they're in your claim folder. Okay. So I hope that, Eddie, I hope that's answered your question as well.
And I'll put that in the chat. I think I'll put it in the, well, can't do it. Well, to speak to what he just mentioned, Eddie, M21, I just pulled it up, and it's talking about the authority or a high-level reviewer. And it says a higher-level reviewer may also change a decision based upon difference of opinion. The higher-level reviewer may not use the difference of opinion to revise the decision in a manner that is less advantageous to the veteran. So that may be a reason why an additional exam was requested, because of the evidence that was presented. It may lean towards your favor, and the reviewer may just need that exam evidence to solidify it. So that could be a reason. Just want to let you know that. So if they do review it, and the reviewer does have the option to overturn a decision based on a difference of opinion, but that exam is needed to do that. And that's the M21. So if you look in for that reference, M21 5.1.b, authority of higher level reviewers.
Can you copy that and put that in the
I put it in a
section?
private chat. I don't have the ability to
hold
enter
on.
into the
Let me,
regular comment.
I'll copy and paste it. Give me
Okay.
1 second. Okay, so I just put in the chat for everyone. It came up in 2 separate chat boxes, but it's there. Okay, so let's get on to the next question. Good Tube Network. Why would VA grant me 70% for adjustment disorder without a CMP exam, then a month later want me to have a CMP exam? Again, that's something that we can't answer. It could be a lot of reasons. And without having a copy of the claims folder or to see what notes were put in there, or if they gave an explanation on the 2507 request. But for them to grant, it could have been something there for them to do that, depending on how long you've been out of service, and who knows. But they should have given an explanation, a detailed explanation in the first rating decision that actually granted that. Now, for them to go back and do another CMP exam, it goes back to what DJ just said. It could have been something that was missed, or that they saw in that exam that wasn't answered, or, who knows? We get a lot of these questions and we just can't answer some of those, because the only person that knows is the person that did it.
Right. And without us having that rating decision and the facts, because,
right,
we like to speak factual. That's why when we give you references, when we tell you things, we try to give you the reference to back it up. But like in this instance, let's say you just got out of service. There's evidence you have a diagnosis, and there's evidence of your symptomology that enables that person to make a decision at that point. So they can give you the rule of thumb they like to follow is to grant if you can. And then, so if they can grant, he or she can grant you 70% now without having all the facts, then they'll go out for an exam, get all the facts. You're 70 now, your symptoms could be 100%. You don't know.
But I would tell you this: you might want to read that rating schedule, general rating schedule criteria for mental conditions, because guess what? If you go to the exam and it shows 30%, that could be a problem. So again, it's about being educated, and that's what a lot of veterans miss. So like DJ said in the high-level review, they have to explain the next hire evaluation. So you'll have that information in that rating decision that granted to 70%. Okay. So I would think one would look at the 50% criteria and 100%, and the 70% is in the middle. Where do you fall? So when you get to that exam, you could reasonably articulate, okay, these, this is what's going on, X, Y, and Z. So you just want to make sure you cover your bases and so forth as you're being educated and prepared before that CMP exam. Let's see. We got Gun Guy. What's going on, Gun Guy? I have a high level review in for GERD. Got favorable opinion from CMP examiner and had a physician do a DBQ nexus for me. So I'm assuming, Gun Guy, you got a copy of that. Got a favorable opinion from. Okay, so you must have a copy of that CMP examiner's, the CMP exam. If you got, a positive opinion, I guess my question to you would be: when you say you had a physician do a DBQ and nexus statement, why go to the CMP exam at that point? Because if you have a DBQ and nexus statement, as long as they were actionable and sufficient, those should have sufficed. But in this case, it did work out in your favor because you're saying that you have a CMP exam.
Right.
So yeah,
looks like could be that he was denied, and in the denial could have said no evidence of a current diagnosis, and then
right.
I don't know, but that's kind of, but good for you. At least you got some things working in your favor. You got favorable
you got some
opinion,
positive,
CMP exam.
Yeah, but again, like you mentioned, in their rating decision, they could have said X, Y, and Z.
Yeah, some of these are hard without having all the facts in front of you. But.
Right. Mr. Howard, my question is: do you have experience with claiming cervical radiculopathy impingement secondary to cervical strain arthritis? Good question. I've seen a few of those, but the majority of them have been with, excuse me, the lower extremity. But it's pretty much the same, just talking about two different nerves: the median nerve in the upper extremities and the sciatic and femoral nerve in the lower extremities. And what I've seen CMP examiners do, and I'll let you weigh on this as well, DJ, is when a veteran service connected for arthritis, sometimes they'll say, you do have a diagnosis of upper extremity or lower extremity, radiculopathy or peripheral neuropathy, but the primary condition is arthritis. Therefore, arthritis can affect the nerve, opposed to a strain where the nerves runs through the muscles. Okay. But I've seen some CMP examiners grant it and some deny it. It just depends on, I think at that point, the CMP examiner. But I've seen them granted more than denials, but I have seen them get denied before. Have you seen that a lot, DJ? Oh,
sorry about that. I was muted.
Okay.
Similar to you, I've seen more dealing with the lumbar versus the cervical, because that's more common. You have the more back injuries than neck, but it can just depends. So the question was, do you have experience with claiming cervical radiculopathy impingement secondary? Yes.
Yeah. All right. Okay, then we go back to good tube. Say, they have already been paying me. Yeah, whenever they service connect you, they're gonna start paying you, from whatever effective date they grant. But again, they're sending you back for that CMP exam. Again, the rating schedule, the general rating schedule criteria for mental conditions. It outlines the occupational impairment along with symptoms. Okay. And you could find those on a DBQ, PTSD DBQ, or other mental condition other than PTSD DBQ as well, because all of them have the the occupational impairment, and then the symptoms on there as well. I'll let you take this one, DJ. You're still muted, DJ.
Okay. That's Mr. Buff Smith back in the house again. All right. He said, hello, guys. Can you appeal after the time frame? So there's a time frame for a reason. So you have to meet that requirement, just like submitting a claim. There's time frames involved with that. But if there's an error, and Dwayne could speak to the clear, unmistakable errors if you want to chime in on that. But if there's an error, then you can cite errors whenever. There's no particular time frame for citing an error. But appeal, if you missed a time frame, you can still submit another claim, but to appeal that and then you're outside the time frame, it just depends on the issue. So there's no I try to stay away from definite answers, because things have exceptions, and without going too deep into it, but I would say you have to see the facts in front of us. We'll have to see the facts and then determine the action.
Now, the notification letter will tell you 365 days when that rating decision, whether they grant a benefit or deny the benefit, they'll tell you your appeal. I think it's in the notification letter, it says appeal rights. It'll tell you 365 days. Now, DJ mentioned CUEs. I did a video last year on CUEs. CUEs never expire. But a lot of veterans do not know what a CUE is and what rises to a level of a CUE. And the burden of proof is you, the veteran. It's on you. So it's like pointing out errors when you file an appeal. On that 0996, I did a video, I think just last week, and they redid the 0996. And on there, they're telling you in instruction pages and even on the actual 0996, it's up to you and your representative to point out those errors. Okay. So same thing with the CUE. You have to, and just you getting a denial and you saying, oh, well, they didn't look at this, it's a CUE. It's not going to rise to the level of a CUE. So again, you're going to need that claims file. But most importantly, CUEs never expire. I've seen CUEs get called going back like 15 years. And the VA just, I think it was a SMCK. And back before VBMS, DJ, we used this thing called RBA 2000. Well, it didn't tell you, like the current program, VBMS, hey, you granted 100%. The veteran has other disabilities totaling 60% or more. Look at SMCK. RBA 2000, I don't think it did that. So you had to know, oh, wait a minute. I got to grant, not SMCK, but SMCS, housebound. Mm. And somebody failed to do it. And the rating was done like, I think 15 years ago. So can you imagine that SMC payout, for 10 to 15 years? It was a lot of money. So, and someone at the VA found it. The vet didn't even catch it. So again, it goes back to being educated, because at that point you could say, hey, wait a minute, I should have been granted SMCS. That's something you don't have to claim if you meet that scheduler criteria. We had a client last year. He submitted a DBQ. We reviewed it to make sure it was actionable and sufficient for rating purposes. He was 100%, and the rater put a routine future. And we gave him the video about the CUE video and the RBSR hearing and a high-level review. And he picked the CUE, and he took that information. We gave him some information from the M21 about CUEs, and he wrote in and he basically told him, I'm calling the CUE on this rating decision. In this rating decision, the rater granted the 100% for, X, Y, and Z, but the rater, the RVSR, failed to grant Chapter 35, aka P&T.
Mm.
The reason why is because on that DBQ, my doctor stated that my condition was permanent. And then he listed the M21 reference that instructs RVSRs when not to schedule routine future exams. So that particular rater violated, and he proved the CUE based off the M21 and the evidence that he submitted. So he was able to reasonably articulate and show that a CUE was committed and gave an M21 reference to bag it up based on the evidence that he submitted and the rating decision. Guess what? 2 weeks later, received that rating decision. That one issue was Chapter 35 benefits, has been granted. So, a lot of people, I said this before, they will get a rating decision that's granting benefits and not even know that there's an error. Luckily, he was a client and we use a secure portal to document exchange. And so we reviewed his rating decision and there it was. And he had no clue. So we had to turn around and educate him on what CUEs was. And then he went out and he did the legwork and he came back, with a positive response. So CUEs, they never expire. So if he would have caught it, let's say 20 years from now, then they would have had to back pay him. Well, there wouldn't have been any back pay involved.
Right.
It was just, Chapter 35 benefits. But what if he had student loan debt? What if he purchased a house? 20 years, he probably would have, his kids going to college. There's a lot of other benefits that you receive outside of the VA for Chapter 35 benefits that particular veteran probably would have missed out on.
That's right.
Yeah. Let's see. We got a few more questions here. Mr. Murray, hey guys, I appreciate you both on the information you provide. Question: if you are 100% total but not permanent, how do you go about becoming permanent if all of your disabilities is static? If you're 100% and you are not Chapter 35, all of your disabilities are not static.
That's right.
You would have to, I would have assumed that you would have to, one, if you don't have a copy of your claims folder to see the rating code sheet goes on there, if all the conditions are static, then yes, an error was made and they should have granted that Chapter 35 benefits. Now, also you can look, if you don't have a copy of your rating claims file that shows your rating code sheet, you can look in all of your rating decisions. In the last sentence in each narrative for each condition, if you see something like, since there's a likelihood of improvement, and I did a video on this, and I last year, how to read a rating.
Yes.
I think it was in September. I did like 5 videos back to back explaining the process from start to finish. And I stated, or I think it was either in one of those in September or the routine future, and what that looks like in the rating decision. But if it says, since there's a likelihood of improvement, that condition is not considered static and they schedule a routine future. You want to add anything to that, DJ?
No, you touched on the main points.
Yeah. So again, there's an M21 reference, and in that RFE YouTube video I did, I listed in the description section that M21 of when a rater is not to schedule a routine future. Like the previous example I just used with one of the clients, the rater just saw the vet is not 55. And a lot of raters think that, since the veteran's not 55 and they're 100%, I got to do a routine future. That's not the case. They have to use their judgment and just say, if they have extra evidence to show that the condition more than likely is permanent, then when not to schedule it. And that's in that M21 as well. Here we go. Brenda, how we doing, Brenda? Should you stay in the supplemental lane until you have all your evidence? You want to take that one, DJ?
Okay. I'm assuming you're saying stay in the supplemental lane as opposed to doing a higher level review. I'm thinking, I'm not sure, but should I stay in the supplemental lane until you have all your evidence? Once you file a claim, you have up to a year to submit all your evidence. So if you're doing a supplemental claim where you need to submit new evidence, then that is your lane. Because higher level review, you can't submit any new evidence, and Board of Veteran Appeals, that's a different lane. So new evidence, supplemental is your way to go.
Yep. Eddie says, thank you. Mr. Mitchell, how do I get a copy of my claims compensation file? Like in the presentation, I say click that show more button in the bottom under, if you'll see my little picture. If you look at any of my videos, you see my little picture and you see my name, you'll see the number of subscribers. Right underneath that, it'll say show more. It's grayed out. Click on it. I put in there verbatim what I did to get a copy of my claims folder. Okay. It's a link to the form that I use. I even provide the fax number and the address of where I sent it. Okay. DJ and we talked about this, I think, in one of our previous live streams. He said, I believe you got yours in what, 4 months, DJ?
Right. It was pretty cool.
And yeah, mine was like 11 months. So I guess they say, hey, that's Dwayne Kimball. We're gonna make him wait. he giving some value. He educating veterans on YouTube, so we're gonna make him wait on his. So Mr. Howard says, thank you, gentlemen. You're welcome. Mr. Moore, I had an appeal in since 2014. Mental disability at 30%. I was granted 70%, but they gave me service connection date of exam instead of the appeal date. They said my condition's gotten worse now. I would say go back and look at that rating decision. More than likely, they should have explained the effective date, and it could have been date. What do they call it? DJ?
Fax file.
Fax file. Yeah, dates fax file. So go back and see if you see that, because what could have happened if you had an exam back in 2014, that exam showed 30%. If you felt you should have been 70, what evidence did you have to show that you should have been 70? So if you had another exam after that, they requested another exam, and that second exam shows 70, then they're going to go from the date fax found. They're not going to go all the way back to the when they gave you the 30%. Now, I have seen that happen before, where the vet, let's just say, was granted 0% for right knee pain because the doctor stated that they had full range of motion and they did not have pain. But when the veteran filed a claim, the veteran says, I have right knee pain. If pain is in that wording, then I can't think of the 38 CFR that gives the RVSR the permission to go ahead and grant 10% based off subjective evidence. So in that situation, then that 10% would have went all the way back to the date that you first filed that claim, But in this instance, obviously they didn't have any evidence in 2014 showing that you were 70%, or it could have been in the claims file. Again, it's hard to say without looking at all of the evidence of record. Jonathan says, what does it mean during a high-level review that a senior is correcting an error, and how long does it take?
Oh, Dwayne, I put that in our private chat. But for those that wanted the reference that Dwayne was talking about, is 38 CFR 4.59.
Okay, and I'm putting it in the regular chat right now. So that goes back to one of our classes, how to be successful in the VA disability compensation claims process. And even when we build educational packets for veterans, that example wording, I even in that how to be successful, we talk about wording that I use to be successful, way I worded each condition, and also in the educational package that we provide for clients, example word in there that they could use as a reference. An educational package, please go out to our website. And if you look on live testimonials, and also they're on YouTube as well, but you could get to them a lot faster on our website. And you can see testimonials, live testimonials from some of our previous clients that opted in and requested that we do educational package for them as well. They give a better detailed response to that. So what did we ask this? What does it mean during a high-level review that scene is correcting an error? How long does it take? I'll take the second part of that. How long does it take? I can't answer that. I could say 3 days and they can get it done in 1 day. There's a lot of variables that go into play. Which regional office is assigned to, the stage of where your claim is at, how many veterans that are before you, which regional office has it been assigned to a lane or a team or a coach? Has a coach assigned it to an individual, and then an individual, how many cases they have before you? I know when I used to rate, whenever we had claims in our queue, we think, it was like 7 days at first, then they knocked it down to 5, then they knocked it down to 3. And I'm like, man, you just put like 10 claims in my queue, and each one of them is like a minimum of 10 issues. I'm not going to be able to, I'm not getting all these done in 3 days, so I don't think anybody can answer that, how long it's going to take. But for senior, I'm assuming that would be a draw. It's probably, and they should have sent you a letter, or even in the rating decision. Sometimes raters don't explain if something is deferred or, why they're doing something. It'd be very vague, but go back and look at that rating decision again, because they could have put it in there as to what the error was, and they're going to make that correction. So go back and read that decision. See, service connection 10% for right lower radiculopathy, sciatic nerve in 2006. Now with foot drop in 2020, VA signed a 20% rating. Is this a low rating for this disability? I don't think it is. And I got my rating. I got my old rating schedule here. But what would foot drop be under? The diagnostic code. First, I would say, I don't think, and this is just, my opinion, I don't think 20% would be low for foot drop. I'm trying to find the diagnostic code for it right quick. That would be what, DJ? Anatomical loss of one.
Well,
anatomical loss of both feet.
And then
loss of use.
You really have to see the exam.
Yeah.
What the findings are.
Exactly. Because whenever you have loss of use, they're 100%. I would say first, the disability breakdown letter will give you that you can call 800-827-1000, and you can go to all my YouTube videos, and I explain this in there. And in that description section, when you click that show more button of how I got a copy of my disability breakdown letter. Because in the rating schedule, it talks about anatomical loss of use, and all these are like at 100%. So when you get that disability breakdown letter, it'll give you that 4-digit diagnostic code, because the loss of use I'm seeing is from 5104 all the way up to 5111. That's for hands, feet, and everything. So when you get that disability breakdown letter, you can see that 4-digit code and see if they actually gave you foot loss. It could be something totally different.
All right.
Okay,
and then,
so that
if it's like a 8521 code, now that's dealing with the external popliteal nerve and a complete okay, I'm going to give you the symptomology that is associated with the percentage. So you asked about 20%. This is associated with 40%, not 20%. So complete foot drop and slight droop of first phalanges of all toes. And then it goes on and on. So that's 85-21, complete foot drop. And then it discusses the other symptomology, and that's 40%. So if you just Google the 38 CFR, go to your specific diagnostic code for whatever they have you rated under for this, because sometimes that can be an error too. You may not know it, but it can have a specific radiculopathy, but a different code. But let's say if it's 85-21, then that'll be 40%. So I'm not totally certain on what your code is and all the symptoms, but that's one with the foot drop.
Right.
85-21.
And I just want to put this up here. Hello, Vanessa Media. For those of you that don't know her, she has a lot of podcasts. She has a lot of information. And I put this up there because a couple of things. Well, one, she's going to interview me this Friday, and I'm really excited, Vanessa. So definitely looking out for that. But I saw a YouTube video pop up on my timeline, and it was kind of disturbing to me. Not the video, but what was disturbing me was she only had 9 views, and this video had been up like a couple of days. But I saw the subject that she was talking about, and she was talking about the White House, the VA White House hotline, and I just did a video a few weeks before that. So I'll watch, I'm subscribed to some channels, fitness and stuff like that. And I'll kind of go through some of the videos. And this wasn't an extremely long video, but I remember watching it from beginning to end because I had some issues with the VA, not the VA White House hotline, but I called them to rectify some issues. So I listened to her story and I was like, wow. And it really resonated. And I left a comment, which I rarely do on certain on YouTube, on other people's channels, but I felt that I needed to. And I was like, I think I was the first one. You let me know, Vanessa, I can't remember, to leave a comment. And then I went to, she had a lot of information in the description section. So again, what I do, I click that show more button, and she had a lot of information, a lot of good information. Then I started watching other videos. I started watching some podcasts. I watched a video where she was interviewing another vet. I can't remember his name. I want to say VA Madness or something like that. But she provides a lot of good information, and the channel is not getting any views. And I'm like, she's telling you, she's sharing her personal story, but also that could be a blueprint because she's telling you some of the issues that she's had, and basically, not the, how you could maybe maneuver and do something different. So Vanessa, hey, I'm really glad to see you tonight. Thanks for chiming in. And I'm definitely looking forward to that interview. And if we go over more than 45 minutes, I'm okay with it, but I understand if you have to cut it short. Okay. So for you, those of you, you'll see her, she's in the comment. Hello, Vanessa Media. If you want to,
Vanessa.
if you want to go ahead and put your YouTube channel link in there, so other veterans on here, they'll see it and get to your channel because you give a lot of good information. And thank you for providing some of your personal experiences as well, Vanessa. Definitely appreciate that.
Yeah, that reminds me of that quote: "A wise man learns from others' mistakes. A fool learns from his own." So
there you go.
She's giving it to you.
Yeah. Oh yeah. Let's see. Just going through. I just lost my place, but I want to. I saw her pop up and leave a message, so I want to get that.
620.
Is this the year for the tolerance for toxic exposure due to VA budget being $6 million instead of a couple million? Mr. Stovall, I'm sorry, Jody Stovall. I do apologize. I didn't know. I just saw Stovall, so I do apologize if you're female and I called you male. I do apologize. I don't keep up with the information on what Congress is doing with the VA. I try to stay more on the changes within the VA. that may have come down from Congress. Like, for example, I'm going to do a video next week about the new 3 Agent Orange exposure presumptives added to 38 CFR 3.309 subpart E. Okay, because the last change they had to that was August 13th, I think 2010 or something like that. Okay, but what Congress doing, the 6 million, that I don't keep up. But I will tell you this: I think Vanessa did do something. I saw something where she was talking about something about Congress and maybe an IG report of Congress, but I don't know exactly. I haven't had a chance to watch her podcast on that. But she's all over the place. She's on, when I mean all over the place, I mean social media. I mean, she's all over social media. It's LinkedIn. She has a channel, a website, which gives a link to all that stuff. YouTube, LinkedIn, a lot of good information. Okay. Melvin Smith, thank you guys. Great information. Brendan Phillips says, thank you. Don't forget, Brendan, tomorrow, our final town hall. So looking for you there. So I'm going to be asking you questions, Ms. Phillips. So tomorrow's not time to be shy with that. Okay. John, have you heard of anyone triggering a reevaluation after completing the VR&E program with TMP or PNT? Was it vocational rehab and education? Voc rehab? That's a tricky question.
Yeah.
I never worked in voc rehab. And one really has nothing to do with the other, so if you go through that program, raters don't get notified of, oh, you're done with this program, go back and look at something. That's not the way it is generated. I never used any voc rehab programs. So yeah, I don't know why that would trigger another reevaluation if you completed a voc rehab program. Yeah. Have you ever seen that or heard of that before, DJ?
No. Well, maybe I'm just trying to think about. I haven't seen it per se, but I don't know. Maybe if it's unemployability.
Okay.
Maybe it's unemployability is involved. So you gotta, you're at 100% permanent total because of unemployability, and now you completed that program and able to be employed. I'm not sure, but like Dwayne said, I don't see how that would trigger it, but possibly because if it's due to unemployability, now the voc rehab finds you capable of employment. Possible.
Obtaining what they say, the gainful
employment.
Gainful employment. Yeah.
Gainful employment. Yes.
Edwin Ortiz, does KMD assist best in finding a doctor for IMO? Mr. Ortiz, IMO. I don't really like that term, IMO, independent medical opinion. I first started hearing about it on YouTube last year. And I asked people, what is an independent medical opinion? What is that? What goes into that? I know what a nexus statement is, and a medical opinion and rationale is in there. So, Mr. Ortiz, you have to be careful with that IMO, because if you go out and pay for this, you want to make sure that you're getting, asking for the correct information, and it is correct when you receive it. Like I said, I didn't start hearing IMOs until last year, and I saw people put it in some of my comment sections, and I was asking people, what is IMO, IMO, IMO? But to answer your question, we just educate veterans. We don't have a staff of doctors or anything like that. But, if you were to go out and get a nexus statement or DBQ, one of our educational services will review that and provide a report for you to ensure that it's actionable and sufficient for rating purposes. Okay. But to answer your question, no, we don't have doctors on staff or anything like that. But that being said, if you do find someone, you still want to make sure that you have the right information. I was talking to a vet last year, and he went and paid a lot of money, hundreds of dollars for an IMO, and he was going in for a simple increase. Therefore, that paperwork that he had was not needed, because in that paperwork he had, none of it referred to the criteria for the next hire evaluation for the increase. And he didn't know that till after, he had a conversation with myself. So you definitely want to make sure you get the right information. You guys are spot on. Just hope that next rater will side favorable for me as well. Hey, I hope that works out for you, gun guy. And also, I see you leave a lot of comments, so definitely appreciate it. So when you get that, maybe on the next live stream or in one of our YouTube videos, just let us know. We like to hear how it works out for you. We always like to hear that positive information. And here you go, DJ. Foot drop, diagnostic code. I think you said 8620, didn't you? Is that what you stated earlier? You're on mute, DJ.
8521, 8620. The 8620 is neuritis. So that's the sciatic nerve. But
I'm trying
is it asking for high level review reason? Or
no, this was the one we were looking at earlier.
Reference to foot drop. The foot drop.
Yeah, the foot drop. Yeah. 8620. I'm just trying to find the diagnostic code criteria.
8620, neuritis. So under the sciatic nerve, so 8620, just neuritis by itself. If you look above it.
Yeah, foot, leg, foot and the leg. So the next higher is mild at 10, moderate at 20,
At 20.
severe at 30, and complete foot drop at 40%. So 20%, do I think that's, I'm not going to say a good evaluation, but, it just depends on your severity. But with that 20%, it tells me that you do not have full foot drop. You do have some type of flexibility in that foot.
And if you search the M21, and there's a court case, Miller versus Shokin, that can help you navigate those waters as well. March 6, 2017.
There you go. That's one of them court cases. Where else can you find them court cases? And then M21 reference associated with any reference you're looking at, they'll be there. All right. Preston, I just filed a CUE for mistake I found in a 1996 migraine decision letter. So Preston, I'm assuming that if you get granted that, you're flying down here to Florida, taking me and DJ out to Roost Chris for a big steak. What you're saying, is that what you're saying, Preston? But hey, I hope you get it. I did a video last year about CUEs. If you hadn't saw it, just go back. It's still some good information. And I used to put the M21 reference in the description section of each video, but a lot of people weren't looking at it. So I was like, I'm not going to put it in there. But for that particular video, I don't know if I did a screenshot and showed the M21 reference. So I stopped putting them in the M21 and started doing slides. So go back and check that video out, and you can kind of gauge. It'll give you, it'll let you know, okay, well, did you think you put enough information to ride? What was the mistake with 38 CFR wasn't followed, or M21 or something like that? And if they haven't made a decision on it, you can always do an addendum, to that. Go back in and say, hey, found, want to clarify the previous CUE, found M21 such and such, or 38 CFR, or court case, or whatever, that shows that I should have been granted a higher percentage for migraines or granted migraines. Kenneth says, VSO officer sent disability claim to VA judge. How long would this take? There's no set time, Kenneth. I will say this, and I think DJ, I don't think you talked about did you talk about the time frames? When you talked about where they used to be compared to where they're at now.
Right.
Yeah.
Right. Yeah. So they give you a window.
Yeah. Right. But to say, they're going to contact you in 50 days, or they're going to, we can't, we don't have a crystal ball. I wish we could, but there's so many variables. You know, you could be assigned a judge, and that judge get sick and be out. Then they have to assign it to another judge. Then that judge workload is just increased. So it could be a number of things that may go into play. But to give a definite time frame, I wish I could, but we can't make that determination. So this makes sense. I'm not IU. I just asking because they're part of VBA. Okay, I think this
that's the
was one
VRE.
Yeah. Yeah. But keep in mind they are part of the VBA, but VBA has some subcomponents to it. Voc Rehab, education department. I get a lot of questions. People say, "Hey, well, how do I use Champ VA?" I don't know. That's on the VHA side.
Right.
I never used Champ VA.
Loan guarantee.
They're under VBA. Exactly. Now, what I know about loan guarantee, I had an individual in my van pool one day that worked in loan guarantee, and I was like, "Hey, what's loan guarantee? What do you all do?" And I still really didn't understand it. And they were like, "Oh, we did,"
Well, those are the people that when you're trying to get that VA loan, they're coming out, they're gonna look at your property and assess it for worthiness. And then
but that's when I did talk to somebody, and they say they do that when they're making, like, if you want to, I guess, a sidewalk or something, or some accessory to you, or something like that.
Are you talking like the improvements?
Yeah, because they have several things that they do, but they will, like DJ said, certain things that'll come out to your home. But when we worked at the regional, they want a different floor in the back somewhere. And the only time we saw them, if you knew somebody back there, or you saw them, the lunch line. And I probably knew like 2 people in loan guarantee, and that was it. Yeah. So a total different entity. It's that time. Greetings, KMD. I am late to the party. Hey, but you're here. So if you got any questions, feel free to shoot. Is aggravation of a pre-existing condition hard to prove? I can use a personal example, and I've used this before. My military career started, I was in the Missouri National Guard. And I say Missouri, not Missouri, Missouri, because I'm country part, okay? So I started the Missouri National Guard in high school. Then I went to college. But on that entrance exam into the National Guard, the doctor noted moderate pes planus, flat feet, right? Was in the National Guard, 4.5 years, 5 years. Was it 4.5? Wow, 5 years. Then I decided to go on active duty and go into the Army. So I go back to the MEP station, and on that entrance exam, it shows moderate flat feet. So I had conditions. I had this condition before I entered military service, active duty. We'll just stick with that, okay? And it shows on 2 entrance exams. While I was in the military, I went on sick call complaining of bilateral foot pain. And then once I got out, I was still getting treatment, and a doctor says, "You have severe pes planus." So that's how I proved that my military service aggravated my pre-service condition, pre-existing service aggravation, pre-service aggravation. Okay. And that's one of the 5 ways of service connection. And that's how I proved it. Now, they denied me right off the bat. And with all that information I just showed you, guess what the VA, the rater said? "We don't see in your medical records that you have pes planus." And so I requested a copy of my claims, my STRs, and there it is thick. Went through them, and I found that information right off the bat. Okay. But it just depends, I think, on the condition and the evidence of record.
And I see a little further down, she cites deviated septum and sleep issues, sleep apnea in particular.
Okay.
Yeah. So I've seen that more times than not, sleep apnea being secondary to deviated septum, as long as you have the evidence lined up, because deviated septum is a respiratory
Right.
issue.
Is that time? Show me how to access the M21. I don't want to click away from this screen, but I'll do one better. I always have these saved in my favorites. So I will put the link to the M21. I do you better. I'll put the link to the M21 in the comment section. So if you go down to the bottom, if you copy and paste that into a URL. Now off to the left, if you get there, you'll see where it says topics. You know, how burial and memorial, compensation, and that's where the M21 is in compensation. And then you'll see the 38 CFRs, the M21 adjudication procedures, the M21-4, and you want to go to the M21 adjudication procedures. That'll have the claimant's rights, general claim information, compensation, pension, Chapter 18, acquired benefits, ancillary, et cetera, et cetera, et cetera. You're still muted, DJ.
Sorry. For Myvery 20, you asked. So if you look up M21, and then in the search engine, just put deviated nasal septum, then it'll bring up the criteria for that. It's all under the respiratory conditions, and it'll tell you about deviated septum and trauma. So it cannot be rated unless there was trauma involved. So, but that'll get you to the information that you need. Again, deviated nasal septum in the search engine. Once you type in M21.
Okay. John asks, Dwayne's always providing good information and answers my questions. Thank you. Y'all feedback. Hey, DJ's on here as well. So, you know, he since he's come on board, I tell you, he's been helping out with a lot. And you can see when we see these questions, you can see DJ, he's pulling this information up right on his computer and providing it, you know, and this is, again, like he stated earlier, this is some good information that everyone here is getting. So, you know, just take heed with it. And, you know, knowledge is power. But a veteran told me today, and this makes sense, it's how you use that knowledge is when that power comes in, because you can be knowledgeable, but if you don't use it, then it's worth nothing. Once you start using it, once you get that education and once you start using it, then it's definitely powerful. So like when some of these people say, hey, I'm following your videos and now I'm 100% permanent total. Hey, they took that information, they continued to get educated, and they went out and they were able to be successful in maximizing their benefits. Okay. I wonder, how do you pronounce that last name? Kidwiller. Okay. I want to make sure I get it right. So if I got it wrong, I do apologize. I filed a claim for chronic sinusitis. Did you just answer this, DJ? Was this the one you talked
No.
about, the diabetes? Okay. I filed a claim for chronic sinusitis, which was denied and not service connected. But the question is, why did they deny it? Why did they say it was denied in a rating decision? That's where you first got to start. Okay. When I was on active duty, I had nasal surgery. I've gone to sick call and had surgery. What should I do? Why did they deny it? It's in the rating decision. Second question, did you get a CMP exam? Third question, if you did get a CMP exam, have you requested a copy of your claims folder, which will have that CMP exam in there? And along with that, it'll show what was noted on that CMP exam and the negative opinion that the doctor provided.
You know, I need to have one of them little buttons when you push it, and when you're on that, when you're spitting that fire, that good information that, you know, hit in there. You know what? Boy, that.
Yeah. So that, you know, that's where you know, you have to start. One, the rating decision, why they denied CMP exam. If you had one, if you did, what was the negative opinion from the doctor. Now, DJ in the presentation, DJ talked about supplemental claim. What is needed to open up a supplemental claim? So more information. One thing we don't do, everyone, we don't advise veterans. We don't say, oh, you should do this or you should do that, other than saying you should get educated. Okay, so we just give you that information and educating you, and what you do with it is what you do with it. Because if I was to say, oh, well, based on this information, if I said, hypothetically, if I said, hey, well, they denied you, do an appeal. And you go an appeal and you lose, you're going to say, well, hey, Dwayne told me to do this and I got denied. So we educate people on, like today, high-level review explained. So now you're a little bit more, hopefully you're a little bit more educated on high-level review. So if you feel you need to enter that process, now you're a little bit more educated and you can navigate it a little bit better, because everybody's situation is different of what they, want to do or how they want to proceed when a denial or grant or whatever the case may be. MGUS, you know what that is? Pre-multiple myeloma presumptive service connected to Gulf War I. There's no such thing as Gulf War I, it's just Gulf War. Now you will see the time frame for Gulf War presumptive for like Iraq and Afghanistan. The dates are different, but the presumptives are the same. I don't think multiple Gulf War is like an undiagnosed illness. And correct me if I'm wrong, DJ, it's more so like before you went to the Gulf, you didn't have something. You came back, now you have a diagnosis of something. And they can't determine why you have this particular diagnosis, other than you start having it when you came back from the Gulf. And then they granted on the Gulf War undiagnosed illness. So
you talk about the MUCMI, medically undiagnosed chronic multi-symptom.
Yeah.
Okay, gotcha.
So it could be any condition. It could be migraines. It could be weight loss, weight gain, COPD, or whatever.
Right.
But even in the M21, it will give you, and then how we give the class how to be successful in the VA claims process. We have a topic on Gulf War presumptives, undiagnosed illness, medically undiagnosed explained illness, et cetera, et cetera, et cetera. And then we go over the dates, because when you get into presumptives, you're going to have dates from start time to end time. Now, I can say this, all the other presumptives, like Agent Orange presumptive, 1 year, 7 year, Camp Lejeune contaminated water presumptive, they have end dates. Gulf War does not have end dates because we still got troops in Afghanistan, Iraq, and in Southwest Asia. Okay, but there are start dates to that.
And that multiple myeloma, if you go to 38 CFR, but go to part 3 and then go to 3.309E, then you'll see under there the diseases associated with exposure to certain herbicide agents. Then you can look to figure out what your presumptive condition is,
right,
and how it relates.
Yeah. Ron Kimbrough, I'm seeking a higher rating for migraines. I'm at 30%. I submitted late statements. Should I have added the fact that my medications have changed as well? Okay. We talked about diagnostic codes. Okay. We talked about rating decisions. When you are granted a percentage, so Mr. Kimbrough, when they granted you 30%, in that rating, they told you the criteria for 50%. In migraines, is diagnostic code 8100. Nowhere in that criteria, it talks about medications. Now, the lay statements, not a bad thing, but do they talk about the 50% criteria? So you either have to Google diagnostic code 8100 to see what the 50% criteria is, or go back to that rating decision that granted you the 30%, and you can see what that criteria is. And then, who best to answer that question? Do you want that 50% better than you? But again, you go to that you go to that exam, how do you reasonably articulate your symptomology as it pertains to the 50%? Is
That's
that what
right.
you was going to say, DJ?
No. I haven't. 50% is with very frequent, completely prostrating and prolonged attacks, productive of severe economic inadaptability. So you can't work because,
Right. Well, it doesn't mean you can't work.
when you have that attack.
Right. But the M21, it gives you the definition of completely prostrating, and
Right.
it gives you the definition of severe economic inadaptability. So once you even get to that criteria, if there's verbiage in there, then you may have to go to the M21 and look at that the definition for it. Okay. Because a lot of veterans say, hey, I'm on medication, I'm this, I'm taking cortisone shots. And I'm like, okay, well, does that meet the criteria for the next higher evaluation?
Right.
I don't know, but I filed a claim for increase.
Yeah. So Ron, go to the 38 CFR Part 4, type in 8100. It's going to take you right to exactly what Dwayne was talking about. Then if you're feeling real froggy, you want to get into the meat of things, go to the M21-1, and then you type in migraines. So it'll take you to the neurological section.
Right. Is that the KMD told me the same thing about my aggravated pest plans for that fee. Still fighting. We'll be in touch. Thank you for testimony. Okay. No problem. Scotty B, good evening. Can any existing condition already rated be evaluated to a higher disability rating? I'm assuming you're asking if you're service connected and you don't file a claim, can they raise that particular percentage? And if that's the case, in most cases, I would say no, unless you were to come in and do some type of action, like actually file a claim for increase, unless it's like prostate cancer or something, or you have a routine future or something like that, that maybe it will be generated an exam somewhere down the road for them to look at it or something. But I mean, I've seen people be 20% for 20 years.
Right.
So
Scotty,
let me know. Go ahead.
Oh, I'm sorry.
DJ.
But Scotty, if you have your rating decision and if you're asking, can I get an increase? Then you find out what that diagnostic code is, or you go to the 38 CFR, you punch in your disability, and then you look at that next higher level of evaluation. So if you're at 10%, then you're trying to go to 20%. You look at the 20%. Or do you have those symptoms for 20%? If you do, then submit for an increase. If you have those symptoms for 50%, going from 10 to 50, same thing. You had those symptoms, then you can pursue an increase.
Yeah. Okay, this is the one you were saying, DJ. Thank you guys. I've been following for about 6 months. I have a question. I've been diagnosed with prostate cancer. Is that a possible VA? Is that the same? I'm at 80% service connected. Cut off. Thank you guys. I've been following for about 8 months. I have a question. I've been diagnosed with prostate cancer. Is that a possible VA? LA. I don't know what LA stands for. Let us know what that LA stands for. Alvin, because I'm at 80% service connected.
Of course, now I've been diagnosed with prostate cancer. Well, I maybe that is that a possible VA claim? Because right below that it says I'm at 80% service connected.
Right.
So prostate cancer, if you're one of those folks that were Vietnam era exposed to Agent Orange, then you have boots on the ground and you can prove that, then that aligns with that. But without having the rest of the evidence,
Yeah.
hard to determine.
It's so many moving parts, and we get asked those questions a lot, and it's hard to provide answers because, when I first started my business, people would say, well, how long did the claim take? And I was like, about 2 months. They call me back 2 weeks later. Hey, I got a rating in the mail. Or I'll say, they're going to take about 2 weeks. It'll be 3 months later. So, I mean, there's so many moving parts. No one can say, hey, we'll be done on, in this particular time frame. Even when the VA say 125 days, I mean, that's just an estimate. That's all that is. It's just an estimate, because if you send in something or somebody doesn't give you due process and they have to go back and do it, now they just extended 30 days onto your claim. And, it could be something else the next time you go to CMP exam, need clarification. They send that addendum back, possibly another 30 days. And at the end of that 30 days, that doesn't mean somebody's going to look at your claim. It could be another 2 weeks after that. Let's see. Got Sean to say, per VBA requirements, chronic sinusitis must be diagnosed and confirmed in medical records in order for it to be service connected. Sean, I'm assuming when you say medical records, are you talking about service treatment records? Because I've seen veterans with, actually, I'm trying to think. I went on sick call, and in my service treatment records, they said possible, under the diagnosis assessment A/P, possible sinusitis. But my main complaint was migraines. And then the question became, okay, when they finally gave me the migraines, the VA says, do you have sinusitis? And, at the time I was like, no, I don't have sinusitis. But they were like, oh, I think it was the draw when I appealed. She said, because we need to get an exam because we see, possible sinusitis in your medical records. But it wasn't chronic. And I was like, no, at that time I was like, no, don't worry about it. I don't have issues with sinusitis or anything like that. But again, if you're saying medical records, service treatment records, also we got to talk about, DJ said this before in live streams, the 3 components to direct service connection. And, what is it? Treatment, complaint, injury, diagnosis, in service, So.
Yeah. And I mean, as far as the sinusitis, it depends, because there may be, to talk about the relationships between upper respiratory tract infection and subsequent issues like chronic sinusitis. So, I mean, we could go down that rabbit hole, but
yeah. Okay, so she said, thank you. You're welcome. Hope we didn't confuse with our answer. When do y'all think that they will start rating and compensating chronic sinusitis and rhinitis? They're doing that now. That's been in the rating scheduler. There's several different types of sinusitis. I think it's like 5 different ones, like frontal, maxillary, and stuff like that. But yeah, and then allergic rhinitis is under a different diagnostic code, and it talks about complete obstruction on one side or 50% obstruction on both sides. If you got polyps, nasal polyps, and stuff like that. But those are
right.
Yeah.
So gun guy, if you go to M21 and just type in sinusitis, the reference is 3.4.4.F.7.B. And in the CFR, that's 4.97. And the diagnostic codes is 6510 through 6514. So that'll talk about chronic sinusitis and rhinitis.
Yep. So it has frontal, maxillary, cephalnoid, and 2 others I can't pronounce. But the first one is all your sinuses, and then the other one's like cheekbone, behind the nasal cavity, each side of forehead, etc. Then it has like a general rating formula for sinusitis for diagnostic codes that DJ just answered. So he's online looking at it. I got my old 2009 rating schedule, which I have to bounce off the online version because that's probably some of that stuff is outdated, but the diagnostic codes he just gave were right on point. He said it's that time marginal camera 3 of, that's what that MGU he stated from, I think that was a Gulf War one. I'll have to Google, I'm not a medical professional. I would have to Google that to see exactly what that is. But again, Gulf War, you have to think about, did you have it, this particular condition before you went to the Gulf, or did you start having issues while you were there and you came back? It's an undiagnosed illness. In my rating decision, they have some things incorrect, so I filed a supplemental claim and noted this denied again. Now what? I guess the question I would have, if you found some things wrong, incorrect in the rating decision, why would there be a need for supplemental claim? Because the supplemental claim, is you're reopening a claim. But if you found something incorrect, is that something you could probably win on appeal, high level review, or was it a CUE? Does it rise to the level of a CUE? So you say, noted this denied again, now what? A claim audit review would have to be done to just begin to dissect the what, when, why.
And KMD offers that service.
Yeah.
But
yeah. So
yours, that's what this whole presentation was about. Your particular case, your particular case. Watch it from the beginning again. And if you need some assistance, reach out to Dwayne. We'll be glad to help you.
Yeah. MG, if I submit a high-level review for a low rating for a mental condition, MDD, can I file for new secondary conditions in the meantime, or do I need to wait until the high level has been closed? Hey, that's a good question. Now I know that changed a couple of times. I don't know if there's any new guidance within the VA, but when I left, and DJ, you could chime in because it could have been different, but if you have MDD on appeal for a higher percentage, and let's just say you claiming hypertension due to the medication that you're taking for MDD. So hypertension due to medication for BDD is a secondary claim. That does not fall under the appeal. That would be a separate issue, a new issue. Now, again, I don't know internally at the VA if that changed, because at one point, if that whatever you were appealing, you come in secondary, then the appeals, and I say appeals because it used to be called appeals back then, but DROC or high level review, I don't know if that's changed, and they say, okay, we got to take issue with that as well. But right before I left, it was broken out because it was separate. It was a separate issue. So at that time, when I left, the high level review team would do the percentage, take care of the percentage for the MDD, and then, at the rating activity level, they would take issue with the secondary conditions, but I don't know if that's changed or not. CS, man, thanks to you and DJ. I'm 100 P&T as of yesterday. Took 4 months. No, my wife always tells me I'm not up on this verbiage.
That sounds like me. I hear the same thing.
I got the 100% P&T. Say Hondo son.
So Hondo with the 100. That's
yeah. Okay. Hondo. Okay. All right. Maybe I'm showing my age. Okay. Hey, well, congratulations, man. Definitely we definitely like to hear those success stories, and that information that you had, that you got educated, or however you got educated. If you got another vet out there, pay it forward, help them, give them some knowledge, and maybe they may not have the hurdles or the mountains to climb like you did, but with your education and what you went through, maybe you could provide some information to them. So congratulations.
Yeah, and especially dispel some of these false narratives going out, because people they're quick to pass on some bad info.
Yeah, just got to make sure that it's correct information, or you could find yourself in a world of hurt. I saw that in an old Marine movie or something. I can't remember which Marine movie that was in. Okay, Gun Guy, you guys awesome. Hey, we definitely appreciate it. Gun Guy, he's an individual that's always on a live stream. I had the opportunity to actually talk to him offline one day for a few minutes. So definitely thank you, Gun Guy, for tuning in for tonight and the positive feedback. Ron says, thank you guys, very helpful. Scotty B, thank you. You're welcome. We'll take a couple more questions, guys. We're at 2 hours and 15 minutes. Going to shut it down. Raymond Renner, I'm a medical discharge for plantar fasciitis, but when I filed a claim, they said it was not service connected. How do you rectify the situation? Got to go back to the rating decision. Again, rating decision will tell you why they denied you. If you had a CMP exam, why did that doctor, if you did, why did that doctor provide a negative opinion? In order to know that, you got to have a CMP exam. How do you do it? If you look in the listed, I got a copy of my claims folder. Before you even get to the rectify, portion of it, everything else, when we do claim audit reviews, people ask us questions like that. I'm like, hey, we got to do a claim audit review for you, and we'll provide a report to show you in this rating decision, this is why they denied it. If you got a copy of your CMP exam, we'll point out the negative medical opinion and then the rationale that the doctor used to support that negative opinion. Then we'll be up to you as a veteran. Okay, well, what I need for supplemental claim, DJ just talked about it earlier, new and relevant evidence. Then the definition of what is new and relevant evidence, there's a 38 CFR. So if you opt into a private Q&A session, then we'll have all that information and go through with you and explain it. And that explanation is what we're doing. We educate you. Okay. Is MGU is undetermined significance? Gulf War presumptive to have checked there. It's still not clear. It's early stages of multiple myeloma is. Oh man, I say he tested my knowledge here. A 1 year presumptive. I don't think multiple. I think multiple myeloma is a 1 year presumptive.
Yeah, but it's under.
No, it's not a multiple myeloma. Is not a 1 year presumptive. It's not a 3 or 7 year. I think it's a 3. I don't have it up, but I think MS multiple sclerosis is 7 year. I don't know if multiple myeloma falls under the 3 year presumptive, meaning you have to be diagnosed with it 3 years after service. But 38 CFR 3.309, what is it? I don't know the CFR that covers the Gulf War. I would have to pull up our presentation that we give. But again, if you go to the M21, it'll break down. It'll give you that 38 CFR. And unlike, Gulf War, unlike Agent Orange, Camp Lejeune, where they have specific diagnoses, okay? 1 year, 3 year, 7 year, Agent Orange, and Camp Lejeune contaminated water, they have specific diagnosis. Now, as it pertains to Gulf War, there are some common diagnoses, like fibromyalgia is one, okay? But it could be a particular skin condition, something like that. They don't have a confirmed list. They'll list some examples of some symptoms that veterans have, had as it pertains to Gulf War. But there's no, I've been seeing like anything like, under Agent Orange, you got diabetes, you got prostate cancer, you got coronary artery disease, something
myeloma.
like that. Right.
Myeloma's under that. That's under the herbicide exposure at 3.309.
Is that a VA claim? I'm a Gulf War veteran, prostate cancer question. Oh, so prostate cancer is not a presumptive under Gulf War. But again, that one I think would probably be hard to kind of to prove because you didn't have it before. So how did the Gulf War, after you came back from the Gulf War, opposed to, let's say, fibromyalgia or a particular skin condition? But there's nothing. I would say no. I never had that asked before. I did not have any blood diseases before the Gulf War. So again, you got to think about, if you look at the M21, 38 CFR, undiagnosed illness. Start there with your research. Undiagnosed illness. And what that means is you have a diagnosis, but they don't know where it stemmed from. Okay. Let's just say you were exposed to a lot of radiation. There's going to be some type of residuals from that. So they're going to know this is why you have these particular residuals. But if you weren't exposed to a lot of radiation, they may not be able to figure out where it generated from. Let's see. It says, I was denied a higher rating for planned fast track. However, the VA's contract exam facility has asked me to come back because they said due to no fault of my own, they missed something. With that, I'll probably be asking, what did you all miss? On the DBQ, blank DBQ, what was missed? I would not want to walk into that exam blind, with that one. Can I call my case is a high? I felt that way about mine at one point. I was like, man, this, just keep plugging it, just keep plugging away, keep plugging away, keep plugging away. Service connect for Hodgkin's lymphoma being treated. Can I secondary service connect the MG US to it? You could claim anything on a secondary basis, but again, there's going to have to be that link. Is it a residual of the Hodgkin's lymphoma? A doctor is going to have to provide a medical opinion and, back it up with a rationale. But you can claim anything secondary. But they'll do an exam and the doctor's going to have to provide a medical opinion.
And Dwayne, in the private chat, I put the M21 reference. So that's for the individuals that are looking for the Gulf War connected disabilities, the qualifying disabilities associated with it.
Okay. All right. So, Mr. Hayward, thank you. That's the last comment we're going to take. There's no other questions after that. We're almost at 2.5 hours. But hey, I'd just like to take this time to thank everyone for joining in. Please like, subscribe, share this video. We will be bringing you more YouTube videos. I think we're going to do a live town hall event with 4 veterans that went through at least 3 events, town hall events. So that'll be our last one. And we're just going to be asking them. We're going to record it. We're going to post it on YouTube. It'll be a private event, but we'll record it and it'll be posted just as a video. So we won't be taking any of the questions after that, but we're just getting their feedback on what they thought about some of the contests that we had in the veteran town halls. The what do we do with a Kahoot quiz? We had 30 questions, and we had a rating decision. So people had a chance to people had a chance to go through and try and put that rating decision together, and that was pretty neat. And we even talked about some of VA quotas at the end for some for some raters that a lot of vets didn't talk about. So I'm pretty sure on Vanessa's interview with me, we probably get into it a little bit deeper. So when that video, when she does it, I'll ask her if I have permission, maybe to post it on my channel or somewhere as well. But and I'll put the link to it in some of my my YouTube videos, so that way you guys, everyone, have access to her podcast. Like I say, a lot of good information. I subscribe to her. Just subscribe to your channel, Vanessa. So I will be checking out more videos. I don't have a lot of time to watch a lot of even personal channels that I subscribe to, but I watched a little bit of the last interview that you did with the previous veteran. I think I did about 30 minutes, 30 minutes or something. So we'll have that coming up for you as well. So again, thanks to everybody. And again, thanks for DJ for putting together that presentation that he did. We do research. I know he does some research to put it together. So everybody show him, give him props on that. And DJ, I'll let you close it out with any feedback or anything you'd like to provide.
For those folks that have issues and trying to look at what disabilities associated with service in Southwest Asia, Google search M21 2-1, and then it'll be what is it? Part 4, subpart 2, chapter 2, section D. So that's part 4, subpart 2, chapter 2, section D, and it'll talk about service connection for qualifying disabilities associated with service in Southwest Asia, and that includes the MUCMEs, what Dwayne was talking about earlier, that the medically unexplained multi-symptom chronic illnesses. So medically unexplained chronic multi-symptom illness. But I'd just like to say that if you disagree with a rating, Dwayne says this all the time. Do you have the rating? Do you have your treatment records? Have you seen the examination? If you have fault in the examination. So everything that you find fault with, do you have it? If you don't have it, then request it. That's your right. Those are your documents. So request it, get them, look at our video. This video, even though it's really focusing on higher level review, you see in there, it'll talk about the 3 different lanes that you have available to you. You know, you have the higher level review, the supplemental, and then the Board of Veterans Appeals. And then it'll tell you the requirements of those. And then we give you the reference so you can go in there and dive deeper into that and find out what's the best avenue for yourself. All of this information is free. It's free and accessible 24 hours a day, whenever you so choose. If you cannot make it over that hurdle at that point, we're here for you. We're here for you. We offer those services. We offer those services. We can walk you through it, educate you, and get you to that point where you're comfortable. And in the future, you can take the reins for yourself. That's ownership. We do that in the military. If you don't know how to do something, you're going to get remedial instruction, and you're going to get it on the spot, because you don't want to be in the trenches with somebody that don't know what they're doing. So we're here for you. We're giving information. We're 2 veterans ourselves, so we have stake in the matter. And just wish all you guys safety, great health, and thank you for your service.
Okay. All right. Take care, everyone, and see you next live stream. And if not, hope to see you in one of our educational classes. Thank you.